A concern group for the underprivileged is calling on the government to plug a legal loophole which deprives casual workers of benefits. Many of the victims are elderly people looking to earn a few extra dollars. Janice Low reports.
Ahead of Labor Day, the Society for Community Organization is pushing the government to plug what it called a loophole in the employment ordinance. Under a so-called 418 clause, workers are considered to be in continuous employment if they work 18 hours or more for 4 consecutive weeks. But SOCO says some employers try to circumvent the rule so as to skimp on medical and other benefits. It noted the most vulnerable groups are usually elderly people working casual shifts. Community Officer Lei Ji-sheng explained how the loophole is exploited. Say a worker has clocked in 18 hours or more for 3 consecutive weeks. The company would then not assign that worker any duty in the 4th week so as to keep him or her out of continuous employment, he said. Among 50 or so elderly employees SOCO talked to in the past 6 months, only 10% of them were entitled to paid sick leave. 2 out of 10 workers also did not enjoy annual leave or any compensation if they are fired on short notice. Many of the interviewees were aware they were deprived of benefits, but decided to stay silent for fear they would lose their jobs. The definition of continuous employment has remained largely intact since 1968, even though a review was completed a decade ago. SOCO urged the government to either ease the weekly working hour requirement from 18 to 16 or allow workers to accumulate 60 hours over 4 weeks. It also called for penalties against wrongful dismissal and the circumvention of labor laws. Janice Low, HKIBC.